Hello aspirants, welcome to Spardha Line. Today we are continuing our next session in the complete Indian Polity through MCQ, and today I am starting the Union Executive and I am going to cover the President, the chapter related to President, and this chapter I am going to cover in detail because from last 2-3 years they are asking questions on the President. Questions are coming in mains as well as in prelims, so in that point of view I am made some formed some MCQs and that we are going to cover in detail now. So we'll move towards the first question. We'll start with first question. This question again one tricky, many of you find it is a wrong question, but I will show you proof for this. So it says that with reference to Union Executive of India, which of the following is not part of it? So option A is the President, option B is the Vice President, option C is the Prime Minister and Council of Minister, and option D is Attorney General of India. Who is not part of the Union Executive? Let me know in comment section, and those who are compatible in Kannada, they can read the Kannada version also. Okay, we'll see, but just going before the answer, I will just give you some facts. So when it comes to Union Executive, it is enriched in Article 52 to Article 78, and these articles, they forms the part 5 of the Indian Constitution. In part 5, the article from 52 to 78, they talks about the Union Executives. Union Executive. Now when it comes to this question, the wrong option is the D, the Attorney General of India. He is not part of Union Executive, and proof for this particular question is the here you can say this is the government profile that know about the India. It talking about the executives. So here they directly says that the Union Executive consists of President, Vice President, the Council of Minister with Prime Minister as the head to head and advise President. Okay, so here they know where they mention about the Attorney General of India, and but in Lakshmikant they have mentioned, but we'll go with the government website, and that we can say that only the President, Vice President, Council of Minister with Prime Minister at its head, they only forms the part of the Union Executive, not Attorney General of India. Okay, so we'll come to our discussion that correct answer is the D. The Attorney General of India is not part of the Union Executive. Okay, so we'll move towards the next question. This question is about the President of India. Okay, the President, first statement says the President act as a symbol of unity, integrity and solidarity of nation. Second, the President is elected not directly by the people but by the Electoral College. Third statement, the President represents both union and state equally. Okay, let me know which one is the correct here. Choose the correct option. Okay, so when it comes to this particular question, the answer is the D, that 1, 2, 3 all statements are correct, because the President, he is the symbol of unity, integrity and solidarity of whole nation, not just a union government. Second, the President is not elected, it's elected not directly by the people. Yes, he is not elected directly by the people, but he elected indirectly through the Electoral College. This we'll see in the next MCQ. Last one, the President represents both union and state equally. Yes, this is the correct. President is equal representative of the union government as well as the state government. Even if it comes to the constitutional amendment, okay, constitutional amendment, the particular procedure in constitutional amendment. So there are the three process. First is that some certain amendments that not considered as amendment under Article 368, certain amendments where you need to have the special majority. Third type of constitutional amendment where you need to have the special majority in parliament and you need to have the ratification by the half of the state. So in that particular aspect, if you see, when it comes to the their union government wants to make changes with respect to office of president, that time what they need to do, they need to take the ratification from the half of the states. Okay, currently 28 states are there, So they need to take the ratification from the 14 state. So it means the president is equal representative of union and the state. Okay, so the correct answer is the D. 1, 2, 3 all are correct. Next question we'll see. So this is about the consider following statement regarding electoral college for the election of the president. Okay, first statement, it includes elected members of both houses of parliament. Second, it includes elected members of both houses of state legislature. Third statement, it includes the elected members of the legislative assemblies of union territories of Delhi, Puducherry and Jammu and Kashmir. So let me know which one is the correct here. Okay, we'll see which one is the correct. But before going to electoral college for president, one fact that you all are aware, or if not, then you must need to know that electoral college for presidential election, it forms with the only elected members. Only the elected members. Okay. So now be the elected members of the Lok Sabha, Raj Sabha or the state legislative assemblies. Okay. It not includes the nominated members. Okay, so nominated members not forms the part of electoral college. So in this regard, the first statement is correct because it is talking about elected members of both houses of parliament. Yes, only elected member. There are 12 nominated members. They don't form the part of the electoral college for presidential election. Second, it includes elected members of both houses. It's not both houses because we know when it comes to state legislature, there are certain states which has the two houses. One is the state legislative assembly and second is the state legislative council. When it comes to state legislative council, it is not formed uniformly. It is not homogeneous. Okay, there are the different composition. Okay, so many of the members are nominated or the indirectly elected through the different electoral college. So this not makes the part of the presidential election. Only the members of state legislative assembly, they take the part of presidential election. So the second statement is wrong here. Last one, it includes elected member of state legislative assemblies of union territory Delhi, Puducherry and Jammu Kashmir. Yes, the three union territories, that is of union territory of Delhi, the Puducherry and Jammu Kashmir, they have the state legislature. Okay, and the members of the state legislature, they makes the part of the, or they are the part of the electoral college for the presidential election. So correct option here is B, that 1 and 3 only are correct. So we'll move towards the next question. It is again about the presidential election in India. So first statement says that the constitution ensure uniformity in scale of representation of different state in the election of president. Second statement, the constitution also ensure the parity between the state as a whole and union in the presidential election. Okay, let me know which one is the correct here. Okay, so these two statements directly copy pasted from the M. Lakshmikan. Both statements are correct. First statement says that the constitution ensure uniformity in scale of representation of the different states in the election of the president. Yes, if you see the formula that needed to calculate the value of MP, it is about the population of the state, the population of state, and it will be divided by the total members of state legislative assembly, and it is to neutralize it or to ensure the uniformity of scale. What they do, they multiply it by 1 divided by 1000. Okay, so what you will get? You will get the more or less uniform weightage for the values of MLA of the different state. So this particular aspect that they have introduced, that forms the, or it is helps in ensuring the uniformity of scale in representation. Second statement, the Constitution also ensure parity between the state as a whole and the union in the presidential election. So means what it is actually saying, the union government, when comes to at union level, the electoral college for presidential election, the electoral college for presidential election, there are two types, one union and the states. So now what it says that the union government, there are the two houses, one is the Lok Sabha and the Raj Sabha. These two houses, the elected members from these two houses has the right to vote in presidential election. When it comes to state, there are the currently 28 states plus 9 union territories. So these 28 states and the 9 union territory and this union government, there should be parity. Means the state, if the union government is getting 100 votes, then all the states, including 28 states and 9 union territory, they must get the 100 votes. So this is nothing but the constitution ensure the parity between union government and state as a whole, because just we have seen the president represent both union and state equally, and for that this is particular provision included, that the state as a whole and the union government, they have the parity when it comes to composition of electoral college. So the correct option is the C. Both 1 and 2 are correct here. So next question we will see. Next question is about again the election of office of the President of India. So when it comes to election office of President of India, first statement says the value of vote of each member of parliament is greater than the member of legislative assembly. Second statement, the election of the president is held in accordance with the system of proportional representation and voting is done by the secret ballot. Third statement, a candidate in order to be declared elected must secure the fixed quota of the votes. Means if the person wants to become the president, he must secure the fixed quota of the vote. So let me know which one is the correct here. Tell which one is the correct option here. So we'll see which one is the correct. First statement says the value of vote of each member of parliament is greater than that of the member of legislative assembly. So it is telling the value of MP is greater than the MLA. Of course it is greater. The value of MP, it is a greater, because when they calculate the value of MLA, we have seen they divide the total population with the elected members of state legislative assembly. When it comes to calculate value of MP, what they do, they calculate or they sum the values of all MLAs across the state and they divide it with the elected members of parliament, and that they will get value. It is something around the 500, and when it comes to state, it is revolves around 200. They differs states by state. But the value of MP is greater than the MLA. In 2023 they asked this kind of question, so at least you need to know these basic things. Second statement, the election of president is held according to a system of proportional representation. Yes, system of proportional representation by single transferable vote. Means what? You need to give the preference. If there are the 4 candidates, 4 candidates A, B, C, D, they are contesting, then what you need to do? So now consider you are the one MP. Now what you need to do? You need to give the preference. So for me, the candidate B, I will give you first preference. Means when they calculate, when they will calculate first time, then my vote will be considered as a vote of the B, candidate B. Then I will give second preference to A candidate, then third preference to C, and fourth preference to D candidate. So first preference, that first time they will calculate my vote goes to the B, candidate B, and if in case that candidate B not secure the fixed quota of vote what is required, if you not secure the 51% vote, then what happens? They calculate these second votes. So that time what they will do, they will consider my second vote that I have given to candidate A, and the second vote will be calculated as a vote of the candidate A. So through this system they will ensure that the total the candidate he will secure this 51%, that is the fixed quota of the votes. So third statement becomes also correct. So the correct option for this is 1, 2, 3, all are correct here. Okay, next question. It is again election of the office of president. So first statement says all doubts, dispute in connection with the presidential election are decided by the Supreme Court of India. Okay. Second, if the electoral college is incomplete, the election of a person as a president can be challenged before the Supreme Court. Third statement, the Supreme Court has original and exclusive jurisdiction in this matter and its decision is final. Supreme Court decision is final. Let me know which one is the correct here. Last D option is the 1, 2 and 3. Okay, we'll see which one is the correct. So all doubts and dispute connection with the presidential election are decided by the Supreme Court. Yes, it is this power given by the Representation of People's Act. It is not decided by the not Representative People Act. There is one particular act which called as Presidential and Vice Presidential Act 1951. This particular act has made the particular provision. It is not provision made by the Constitution. Constitution left it on the Parliament, and Parliament brought this particular law, that is Presidential and Vice Presidential Act 1951. In that act, they decided if the dispute or doubts arises out of the presidential election, that then it will be decided by the Supreme Court of India. So the first statement is correct. Second statement, if electoral college is incomplete. Electoral college is incomplete means what? So when we saw the electoral college, when it comes to union government, 2 houses, elected members of 2 houses will vote, and when it comes to the state, the members of state legislative assemblies of all state will vote. Now, for example, if the legislative assembly of UP it is suspended because of the president rule or the election is not held, so this electoral college is incomplete because the member of the this Uttar Pradesh, they cannot vote for the presidential election. So in this case, if the person who if considering that there is no presentation from Uttar Pradesh and the presidential election held, so it cannot be challenged. Okay, so it doesn't matter whether the people from the elected members of the UP Legislative Assembly present or not. Okay, even if there is electoral college is incomplete, the person who will be elected as president, it cannot be challenged. So incomplete electoral college, it is not a ground to challenge the presidential election. Okay, so the second statement is wrong here. Last statement, the Supreme Court has original and exclusive jurisdiction in this matter. Yes, original means you first, or when you do the go for the press litigation, that time you must go to Supreme Court, not anywhere else. And exclusive means only the Supreme Court will decide, not any other court. Okay, so that's why the third statement is also correct. So the correct option is the B, that 1 and 3 are correct here. Next question. So it talks about with reference to qualification required for the election of President of India. What is the qualification required? He or she must be citizen of India by birth. Second, he or she must have completed 35 years of age. Third one, she must qualify for the election as a member of Lok Sabha. Fourth one, she must make the security deposit of 15,000 with the State Bank of India. Last one, his or her nomination paper must be subscribed by at least 100 proposers. Okay, so let me know how many of these out of 5 criteria, how many are correct. Okay, we'll see first one. First says that he or she must be citizen of India by birth. No, that person can be citizen of India by birth as well as by naturalization. Naturalization means they can acquire the citizenship through the descent. Okay, if they are completed that minimum resident criteria or the years of residence that they need to stay in India. If they are fulfilling that one, they can become the or they can run for the election of president. Okay, so first statement is wrong. When it comes to the USA, then this statement becomes correct. There they need to be citizen of citizen by the birth, but our case birth and naturalization both are valid. Second, he or she must have completed age of 35. Yes, this is correct. Third one, he qualified for the election of Lok Sabha. Yes. Now fourth one, he or she must make the security deposit 50,000. Till here it is correct, but it is not with State Bank of India. It is with Reserve Bank of India. So for that you need to have the concentration and you need to read carefully, because this kind of question they ask in PSI or Group C level examination. Last one, his or her nomination paper must be subscribed by the 100 proposer, at least 100 proposer. This is wrong, because there should be total 100 members or 100 subscribers. Out of these 100 subscribers, 50 should be proposers, 50 should be proposers and 50 should be seconder. Okay, then total 100 members or 100 people need to subscribe it, but when it comes to proposal it is only 50, not 100. So this statement is also wrong. So they are asking how many of the correct. Second is correct, third is correct, and first, third, fourth and fifth is wrong. So correct option is the A, that only 2 are correct here. Okay, so we'll move towards the next question. This is again about the President of India. So the first statement says the President takes an oath to safeguard the sovereignty, integrity of India. Second, the Constitution empowers the Parliament to determine the salary, allowance and the privilege of office of the President. Third statement, the President enjoys complete legal immunity from any civil and criminal proceeding in respect of his or her personal act. Okay, let me know which one is the correct here. Okay, we'll see which one is the correct. First is wrong, because President don't take oath of to safeguard sovereignty, integrity of India. He takes the oath of the preserve, protect and defend the Constitution and the India. Okay, so it is not about the India. He takes the oath of the to preserve, defend Constitution. Okay, not country. Second statement, the Constitution empowers Parliament to determine salary, allowance, privilege of the President. Yes, Constitution allowed this to do. Last statement, President enjoy complete legal immunity from the civil and criminal proceeding in respect of personal act. This is not correct, because he enjoyed the complete legal immunity when it comes to the criminal proceeding. Okay, criminal proceeding, if he has done certain personal act and that act counted as a criminal in nature, then he will get the complete legal immunity until he or she is acting as a President of India. But when it comes to civil proceeding, they will not get such a legal immunity. The proceeding can be initiated after giving the initial notice. So the third statement is also wrong. Correct is here B, that 2 is only correct. So next we will see. Next is about again the consider following statement regarding office of President. First statement says the President can hold office beyond his or her term of 5 years until the successor assume the charge. Okay, second, the President can be removed from office by process of impeachment for violation of the Constitution. Last statement, the President act as a or the Vice President act as a President during the expiration of Vice President's term. Okay, which one is the correct here? Okay, we'll see which one is the correct. The president can hold office beyond his or her term of 5 years until successor assume charge. Yes, this is provision made by the constitution to avoid the interregnum. Okay, if there is a certain 5 or 10 days election is held for the presidential election, next candidate is elected for the office of president, but there are certain circumstances arises that the person elected president elect, he cannot assume the duty for that particular period. The sitting president can resume until the that president elect take the charge. Okay, that time it is not allowed the vice president to become as a president. Okay, so the first statement is correct, third becomes wrong. Second statement, if you see, the president can be removed from the office by the process of impeachment and for violation of constitution. This particular mentioned in constitution that president can be removed for the violation of constitution, but constitution doesn't define that what is violation of constitution. Now when it comes to the impeachment process, the impeachment of president, so what are the condition? This impeachment charges, it can be either initiated in Lok Sabha and Rajya Sabha. Okay, in either house, be it Lok Sabha and Rajya Sabha. But for initiating process, what you need to do? Suppose it is initiating in Lok Sabha, the 1/4 members of Lok Sabha, they must pass the motion, or they must they sign that particular impeachment charges, then only it will be considered. Okay, next step is that particular impeachment motion after when the 1/4 members of Lok Sabha signs, so that time next part is the proceeding or the inquiry will be held. Okay, this inquiry can be held in Lok Sabha because the charges initiated in Lok Sabha. So this inquiry will be in quasi judicial in nature. Okay, why an inquiry? Because he can be removed from the violation of constitution. Constitution doesn't apply to whether to assess that that particular person is violating the constitution or not. For that there needs to be inquiry. If the inquiry, through the inquiry, the particular this condition fulfills, that sitting president has violated the constitution, then what happens? This particular impeachment motion, will be charged, it will be voted by the 2/3 members. Okay, 2/3 members of both houses. Both houses mean 2/3 members of Lok Sabha means what? 2/3 of 543, and when it comes to Rajya Sabha also, the 2/3 of 245. These people must charge the or vote in favor of the impeachment motion. That time it will be considered as a passed. Okay, here that particular only 2/3 members need to be vote in favor of impeachment motion. There is no condition of that 272. Okay, that one kind of the special majority. Okay, the half of the strength of the house, and in addition to this 2/3 present and voting, that is not here. Only the 2/3 members of the particular house need to sign this particular impeachment motion, then it is considered as passed. So this is about the impeachment motion. Now the correct answer for this question is the A, that 1 and 2 are correct. Next question will say, so it is assertion reasoning. Now again the impeachment charge. Okay, impeachment charge against the president can be initiated in either house of parliament, just I have told. So either house, they can initiate in Lok Sabha, they can initiate in Rajya Sabha. Second, the such charges must be signed at least 1/4 of total members of the house moving the resolution. Yes, just I have told you that 1/4 member must sign this particular resolution. Okay, if it initiating in Lok Sabha, the 1/4 of how much it is, the 543. If the initiating in Lok Sabha, then 1/4 of 245. These member must sign in initial to pass the resolution. Okay, so the both statements are correct, but there is no linkage between the two statements. So option correct option is here B, that statement 1 and statement 2 is correct, but the statement 2 is not correct explanation of statement 1. Okay, so we'll move towards the next question now. It is okay, there are certain circumstances. So it is asking, in which of following circumstances can be Vice President of India act as a president? Okay, so if the vacancy is arising because the expiry of presidential tenure Second, vacancy because of resignation of sitting president, vacancy on removal of sitting president, vacancy on death of sitting president, vacancy on election of president declared void by the Supreme Court. So in which of the condition or the circumstances the vice president can act as a president? Let me know which one is the correct here. Okay, we'll see which one is the correct. Now, just we have seen when it comes to vacancies because of expiry of presidential tenure, that time the sitting president will resume until his successor takes the charges. So that time the vice president will not get the chance to act as a president. So first is wrong. Second is vacancy because of a resignation. Okay, that time the vice president can act as a president. Yes, correct. Third one, if the sitting president is removed, that time vice president can act as a president. Yes. When if death of sitting president happened, then vice president, yes, happens because there is condition. First time when the Dr. Zakir Hussain, the third president of India, he died in office. That time the president, the vice president took the charges. Even when the this after this also V.V. Giri, the other president who died in the office, that time that vice president, they acted as a president that time. Okay, so fifth also, the election of presidential declare void. Yes, that time also, because there is a condition, if the seat of the president, office of president become vacant, so that time the vacancy should be filled in 6 months. Okay, for to complete election procedure, there is the 2 months, minimum 2 months required to fulfill the or the complete the election procedure. So if you are aware of the there, I told you presidential and vice presidential act is there. In this particular act, it gives the 34-day, this 34-day statutory period for the election commission to complete the electoral process. Okay, once if the election commission declares the vice of president will be held, so they must complete entire process within the 34 days. Okay, so for that time the vice president act as a president. Okay, but in this only these 4 circumstances. Okay, so correct option is the only 4, that is C is correct here. Next question we'll see. So it is about the executive power of president. So first statement says all executive action of the government of India are formally taken in the name of president. The president directly administers the union territories through administrator appointed by him or her. Last one, the president can declare any area as a scheduled area and administer it under his or her direct control. Okay, let me know which one is the correct here. Okay, so we'll see which one is the correct. First statement, all executive actions of government of India is formally taken in the name of president. Yes, the president is head of the state, so all the executive actions of India, it will be taken on the name of the president. Second statement, the president directly administers union territory through administrator appointed by him or her. Yes, this is also correct. He directly administers union territories. Okay, administers, there are different designation. For Union territory with legislature, they call it lieutenant governor, and Union territory with not legislature, they call it as administrator. Okay. Third statement, the president can declare any area scheduled area and administer under direct control. No direct control, but he administer, or he or she can give the direction to state government, but it will be administered by the governor, and governor will administer with the aid and advice of council of minister, and this will be headed by the chief minister. Okay, so the third statement is wrong here. Correct option is the A, that A and 1 and 2 only are correct. Next question. So it is about the powers of president of India. Okay, so first statement says the president of India can grant pardon to any person sentenced to death, but only on the advice of the council of minister. Second, the president can declare war or conclude the peace only with the prior approval of Council of Ministers. Third one, the president can conclude the international treaty and agreement with the prior approval of Council of Ministers. Okay, let me know which one is the correct here. Okay, we'll see which one is the correct. President can grant pardon to any person sentenced to death, but only advice of Council of Ministers. Yes, because any decision taken by the President of India, it must be after the aid and advice of the Council of Ministers. So if he is taking any decision on his or her discretion, then it is not considered as valid, or it will be considered as unconstitutional. Second statement, the president can declare war and conclude peace only with prior approval of the Council of Ministers. Not prior approval, but with, after the concluding, they need to take approval of the Parliament. So the president and after the advice of the Council of Ministers, he can declare war or conclude peace, but it need to be taken. There need to be taken approval of the Parliament. Last one, the president conclude international treaty agreement with approval of the Council of Ministers. Not Council of Ministers, but approval. When it comes to approval, they need to be take approval of the Parliament. There is no need of approval of Council of Ministers because he will be taking that decision after advice of the Council of Ministers. So third is also wrong here. Okay, so correct option should be only A. The options are missed here. Okay, next question we'll see. So here, with reference to veto powers of President of India, consider the following type. How many of our veto powers are actually enjoyed by the President of India? So absolute veto, suspensive veto, qualified veto, pocket veto. How many of these enjoyed by the President of India? Let me know. Okay, so we'll see which one is the correct. So when it comes to this particular veto, absolute veto, we will all know President, he will withhold his decision. He will withhold decision. Okay, he will not ratify it. So this particular veto is exercised when the bill is passed by the private members bill passed or government resigns before the presidential assent. Okay, that time this veto power is exercised. Second is suspensive veto. In that, what happens? The president has power to return the bill to Parliament. Okay, when the bill presented to president has three types of, when come for the assent, he has the three options. Okay, he can give his assent, he can withhold his assent, or he can send the particular bill for the reconsideration of the Parliament. So in case of if he given the bill for the reconsideration, that time what happens? Parliament again pass it bill, whatever the majority. If the other statutory bills are there, Parliament can pass it with the ordinary majority. So that time what happens? The president has no power, but he need to give the assent. Okay, this is suspensive veto they call. Qualified veto is another version. It is mostly prevalent in USA. If now the president has given the bill for reconsideration, okay, suppose there is one ordinary act. For example, there is act for the ban on cow slaughter. Okay, the ban on cow slaughter, this is act. For this, to pass this particular act, what the Parliament need to do? When it comes to Lok Sabha, they need to pass with majority of 272 plus. When it comes to Rajya Sabha, they need to pass with majority of 123 plus. Okay, this is ordinary majority. But president feels that the EP president resend the bill to Parliament for reconsideration. Then Lok Sabha or Rajya Sabha, they can pass it with same majority. Okay, but when what happens in qualified veto, the Lok Sabha, it will pass with a 2/3 majority. Okay, and Rajya Sabha also will pass in 2/3 majority. Okay, so that time the president has to give assent, but it is not in case of India, it is in case of the USA. So the after the when the bill given by the president for reconsideration, that time what parliament does, it passes with a higher majority. Okay, and this is present in USA, not in India. Last one is the pocket veto. So president, he will not take any action, he will not recognize the bill, or he will not give assent, or he will not withhold it. Okay, he will not take, simply not take any action. Okay, so this is called pocket veto. So for Indian president, there is no time frame. Okay, so he can for indefinite period he can hold the particular bill. But when it comes to USA president, in 10 days when parliament gives him bill to for his assent, in 10 days he need to give his assent. But in case of president of India, there is no such time limit. So that's why it is called pocket of Indian president is bigger than the US president. Okay, so again, when it comes to this veto power, the veto power can be exercised only on the ordinary bills. The ordinary bills, this all type of the absolute, suspensive and pocket, these all, when it comes to ordinary bills, the president can exercise this all three kinds of veto. When it comes to the money bill, that time president has only one option, the absolute veto. He can either withhold or give his assent. He cannot return it for reconsideration. Okay, when it comes to constitutional amendment bill, okay, we have the three types of bill, that is money bill, ordinary bill, and constitutional amendment bill. Now the last is constitutional amendment bill. The president cannot exercise any veto, because after the 24th Constitutional Amendment Act, the 24th Constitutional Amendment Act, it is obliged the president that he must give his assent on the constitutional amendment bill. So that time president cannot enjoy any kind of will. Okay, so in these circumstances, what are the veto powers the president enjoy? The qualified veto is not enjoyed by the Indian president, but other three are enjoyed in different contexts. So the correct option is the C, that only three is correct. Next question. The consider following statement regarding the veto power, but it is over the state legislation or the state legislative act. First statement, the bill passed by state legislature can become act only after receiving the assent of either governor or if reserved the president. Second statement, the constitution does not prescribe any time limit within which president must decide on the bill reserved for his or her consideration. Third one, the president enjoys suspensive veto over the state bill reserved for his or her consideration. Okay, let me know which one is the correct here. Okay, we'll see which one is the correct. First statement, a bill passed by state legislature can become act only after receiving the assent of the governor. So when it comes to governor assent, it is article 200. Okay, so in article sorry, not 200, it is article actually I forgot. When it comes to reservation, the governor can reserve the bill for the president. It is under article 200, and the president give his assent under this, covers under article 201. Okay, so if the bill reserved for the governor under article 200, okay, the president has power under 201. Okay, so this statement is correct. Second, the constitution does not prescribe any time limit within which president must decide on the bill reserved for his or her consideration. Yes, because there is no time limit, because once the governor of state, he reserved bill under article 200, the president under article 201, he has the four option. He can give his assent, he can withhold assent, okay, he can send it to reconsideration of parliament or state legislature. Okay, these three types of assent he enjoys, three types of veto. Now the last statement, UPSC president enjoys suspensive veto, because when president send the bill for reconsideration of state legislature, that time state legislature cannot override him. So override him means the state cannot pass the bill again, and it is, even state legislature pass this bill again, it is not legally or constitutionally binding on the president to give his assent. But in case of parliament, he must give his assent if the same bill passed by the Parliament when it is for its reconsideration. So this not applies to the state legislature. So this third statement is also correct, that president enjoy the sorry, it is wrong because president doesn't enjoy the suspensive power. So the third is wrong. Correct option is the A and 2 only. Next question we'll see. It is considered following statement president's veto power over state legislation. I guess again it is repeated. Okay, I guess. Third one is ordinance making power of the president under Article 123 of the Constitution. So first statement says the power of president to promulgate ordinance is not parallel to a parallel power of legislation. Second, the ordinance making power of the president is coextensive with the legislative power of parliament. Third, the rules of procedure of Lok Sabha require that every ordinance laid before it must be accompanied by the statement explaining the circumstances that necessitated immediate legislation through the ordinance. Okay, let me know which one is the correct here. Okay, we'll see which one is the correct. This Article 123, it is about the ordinance making power of the president. Okay, first statement says the power of president to promulgate ordinance is not parallel power of legislation. Yes, it is not parallel power of legislation because when the president can promulgate ordinance, there is the circumstances when the parliament is there. Parliament has the two houses, Lok Sabha and Raj Sabha. Now, if there should in first condition, these both houses should not be in session. Okay, both houses should not be in session. Second condition, at least one house. Okay, at least one house should not be in session. In these two circumstances only, the president can make the ordinance. Okay, so means if the two houses, these both houses are in session. Okay, so at that time president cannot make the ordinance or he cannot issue the ordinance. So this is, if the president is issuing ordinance when the both houses are in session, then it is considered as parallel power, but this is not allowed by the constitution. So first statement becomes the wrong. Okay, sorry, first statement is correct, that is, it is explaining the truth that it is not a parallel power. Second statement, the ordinance making power of president is coextensive with the legislative power, the legislative power of parliament. Yes, because the president can make the law or he can issue ordinance only on the subject mentioned in union list and concurrent list. Okay, concurrent list in normal circumstances. So he cannot make the ordinance on the state subject. Okay, so this is where the parliament has the right to make the power. But when it comes to duration, parliament's law, it can be in force for indefinite period. Okay, until parliament brings other law to repeal it. But when it comes to presidential ordinance, it can remain in force for 6 months and 6 weeks. Okay, so it must be passed by the parliament, or parliament must ratify the bill in 6 months and 6 weeks, because after when parliament session starts, so within the 6 weeks parliament must pass this or ratify the ordinance, then only it is considered as valid. Okay, unless it is considered as repealed. Last is also correct, because the rules of procedure of Lok Sabha, it requires that every ordinance, whatever ordinance made by the president, okay, so when it laid before the Lok Sabha, that time the government or the president, union government, it must explain what was the circumstances that necessitated or led to immediate legislation to ordinance. Okay, they need to explain it to Lok Sabha. Okay, so this third statement is also correct. Correct option is the D, 1, 2, 3 and correct. Next question we'll see. It is about Article 72 and 161, that is the pardoning power of president and the governor. First statement says that pardoning power of the president is executive power and it is independent of judiciary. President and governor of the state have the concurrent power in respect of suspension, remission, commutation of death sentence. Last, Supreme Court of India has laid down procedural guidelines for the exercise of president's pardoning power. Okay, let me know which one is the correct here. Okay, we'll see which one is correct. First, it says pardoning power of president is executive power. Yes, because he will take decision after aid and advice of council of minister. So it is independent of judiciary. Okay, this is also correct. It is not judiciary. No need to lay down any guidelines or it is not judicial because the person who is going to president for the pardoning, he cannot cannot go for the inquiry. Okay, there should not be inquiry or the hearing can be heard before the president. So that's why it is independent of judiciary. Okay. Second statement, the president and governor of the state concurrent power with respect to suspension, remission, commutation of death sentence. Yes, because both president and governor, they can suspend, remit or the commute the death sentence. But when it comes to pardoning death sentence, the pardoning death sentence, it is exclusively given to the president. Okay. Now, be it the pardoning, the death sentence given based on the Indian law, even though it is given based on the state law, or it is given after martial law. So in all the circumstances, only president can give the pardoning for the death sentence, not the governor. But when it comes to suspend, remission and the commutation, both have the concurrent power. So this statement is correct. Last, when Supreme Court has laid down the procedure guidelines, it is not laid down the procedure guidelines. It is had laid down the certain principles, and that principles itself, Supreme Court said that there is no need of the guidelines for the president to exercise his pardoning power because it is independent of judiciary. So the third statement is wrong. Correct option is the A. That is A and 2 are 1 and 2 are correct here. Next statement we will see. Next question. This is the last question, I guess. So it is about the executive power of union. So first statement says that the constitution vests executive power of union in the president. Second, the president can exercise this power directly without the aid and advice of the council of minister. Third statement, the president may require the council of minister to reconsider its advice but bound by the advice after reconsideration. Okay, so this is I will discuss briefly. So first statement is correct because all the executive power of union government, it lies with the president of India. So this is the correct. Second statement, the president can exercise this power directly he cannot do anything without the aid and advice of council of minister. So this is the wrong. Okay, second statement is wrong. Last one, third one, the president may require the council of minister to reconsider its advice but bound by the advice given by the after reconsideration. So what happened when 42nd constitutional amendment came, it made the president to bound. Okay, whatever the aid and advice council of minister will give, the president will be bounded by this advice. But 44th constitutional amendment, it made the one change. Okay, it allowed president to give the advice of the council of minister for the reconsideration. So any advice or aid given by the council of minister, the president can give it is for the reconsideration. But when they will reconsider and again they will give to president, that time the president is bound to act as per the advice. So the third statement is correct. So correct option is the C, that 1 and 3 are correct. Okay, so with this we are finishing today's discussion. We have seen the president of India in detail. So next session we'll discuss about the council of minister, the prime minister, the vice president, and some certain facts that are related about the cabinet committee. Okay, so this thing we'll discuss in next session. For today, thank you very much.